Hello everybody and welcome to Jeff the Pharmacist. It's an honor to have you here. So I want to talk about a prep class that I've made. It's called the it's for the multi-state pharmacist jurisprudence exam, also called the MPJE or simply the law exam. So I've created a prep class for the federal portion of the exam. Just a little backstory on me. I'm a pharmacist licensed in 3 states, so that's Delaware, Florida, and Maryland, where I practice. And after my last exam, the Delaware exam, I was like, this is getting pretty easy. So I thought I would pass it on to you guys by creating a course to help you guys pass the exam. So I know there are other offerings. What sets mine apart is you know who created it. It's me. I'm right here in front of you. There's no, there's nothing goofy, no fancy marketing gimmicks or anything like that. The first lecture is here before you, so if you want to keep going, just click on the link to the prep course. It's $60 if you want to keep going. If you don't and you just want to use this lecture, go ahead. I hope it helps you, and I know you're gonna pass. I know you're gonna do a great job and be a kick-ass pharmacist. My first lecture is on the drugs that established the FDA and kind of established the current federal framework that we work under. So the important laws are the Pure Food and Drug Act of 1906, the Federal Food, Drug, and Cosmetic Act of 1938, the Durham-Humphrey Amendment of 1951, and the Kefauver-Harris Amendment of 1962. And these these were gradual increments to the FDA's authority, starting with a very kind of like a landmark bill, but not definitely didn't give the government that much power. Kind of an homage to our revolutionary past. We've always resisted regulation. We've always resisted regulation, and 1906 was no different. So the Pure Food and Drug Act of 1906 declared that drugs could not be adulterated or misbranded prior to entering interstate commerce. So the FDA grants its authority by controlling interstate commerce of drugs across state lines. So that includes transporting drugs across state lines, accepting payment for them across state lines, the shipment of ingredients across state lines, because that's the federal government's purview, is controlling interstate commerce. Basically the language of the law is drugs could not be misbranded or adulterated prior to entering interstate commerce. Now the Pure Food and Drug Act of 1906 began as kind of a muckraking journalist story. So journalists that advocated for workers' rights and the purity of the food and drug supply were advocating the Pure Food and Drug Act of 1906, and that's kind of what pushed the law along. Journalists that basically kind of targeted different companies and they were basically trying to change society to improve, basically to improve the health and lives of consumers. A famous example, and may have been what spawned the law, was The Jungle by Upton Sinclair, and that book famously depicted a worker falling into a meat rendering vat and becoming part of the U.S. food supply. So that kind of started the food part of the concern, and Theodore Roosevelt was president at the time, and he was famous for bringing the trusts. He was a trust buster, and he was pro-federal regulation. At the same time, there was this patent medicine industry, which it's worked its way into the lexicon now, where if you want to insult a salesman, you call him a snake oil salesman for being slick and dishonest. And that's what was occurring with medications. There was numerous patent medications. You could basically start up a shop anywhere, put anything in a bottle and sell it, because it's basically you're right to, as a consumer, to buy anything, and a businessman's right to sell anything to you. So there are all these famous products, and you might even see them on old bulletin boards or old signs at garage sales, or some of the names were kind of funny, so I included them. The law is boring, so I tried to include some of these names. Dr. Morse's Indian Root Pills, Dr. Williams Pink Pills for Pale People, Hamlin's Wizard Oils. There's also a snake oil, Mrs. Moffat's Shoe Fly Powders for drunkenness. And these patent medicines made claims that they could cure cancer, they could cure basically any kind of an ailment, any kind of a situation. They could be given to little babies, children, what have you. All you had to have was the label itself that's selling the drug. You didn't have to include any ingredients, and the medication itself was patented. So the law tried to address some of this, but also was trying to protect the industry a little bit. So it basically established that drugs could not enter the market that were misbranded or adulterated. They could not engage in interstate commerce. So what is misbranding? So misbranding established that a patent medication could not be a knockoff of another and have the same label. It also established certain minimum labeling requirements. So if you had a number of dangerous ingredients in your product, you had to state that on the label, which was a big step, because before you could put anything in there and you wouldn't have to say what was in it at all. So if you had a product, and this is what the law said. First, if it be an imitation of or offered for sale under the name of another article, so it could not be another product. It could not be an imitation of another product already offered for sale. If the contents of the package as originally put up shall have been removed in whole or in part, and other contents shall have been placed in such a package. Again, that just goes to you can't claim it's something it's not. And if it contained alcohol, morphine, opium, cocaine, heroin, alpha or beta usane, chloroform, cannabis, indica, chlorohydrate, acetanilide, or any derivative or preparation of any such substances, you had to put it on the label, or that product was misbranded. The U.S. Bureau of Chemistry could come to your factory and destroy your product if it was misbranded. Now, adulteration was a bit different. If you claim that the product was 100%, or if you claim the product was aspirin, for instance, you had to follow the guidelines by the United States Pharmacopoeia or National Formulary, which is basically a society that governs purity standards for certain drugs. You were allowed to dilute it, you just had to state that on the label. So you could have aspirin USP, but you could also dilute that if you wanted to 50% aspirin USP or whatever. You just had to be honest about it on the label, what it was. But if you had a patent medication that was a mixture and you weren't making claims about it having something in the USP, you did not have to state that. And it also established the USP or National Formulary as the purity standard for drugs in the United States, and they still are. They're like a company that still operates, and they're still in federal law. And you know if you look at any product, you might see HCTZ. It'll say USP on there often, just as an indicator that it follows the strength and purity standards of the USP. And that's in the law to this day. So the first law, the 1906 law, the Pure Food and Drug Act of 1906, was a weak law. the U.S. government kicked it up a notch. So it was Teddy Roosevelt that started the whole thing, and then Franklin Delano Roosevelt kicked it up a notch with the Federal Food, Drug, and Cosmetic Act of 1938. The most important thing that you need to remember about that is that it required drugs to prove to the government, drug companies to prove to the government that the product was safe. So not effective. So if it was a sugar pill, you could market sugar pills all night long. That was fine. But it didn't have to be proven effective. Now this was a result of something called the sulfanilamide disaster, and that was a drug that was marketed by a company called S.E. Massengill Company, basically a chemistry company. They synthesized this product, they believed that it would be safe, and they marketed it, and 100 people died from it. And there were other smaller cases of people having injuries or having muscle dystrophy or different paralysis from some of these patent medications, but this was such a large case, and the politics surrounding it were right, and you had a new law requiring effectiveness, and that is also established the Federal Food, Drug, and Cosmetic Act, established the NDA, or the New Drug Application. So companies were required to submit the new drug application. The onus was on the FDA to rule against it. So within 60 days, it was automatically approved. So if the FDA didn't do anything on it, it was automatically approved. Now the Durham-Humphrey Amendment of 1951 established over-the-counter and RX categories. So the drug was to be over-the-counter unless, number one, it was habit-forming, number two, had potentially harmful effects or potentially harmful effects when used by a layperson, a non-medical provider, and was limited to prescription use by a new drug application. So when drug companies were sending in their NDAs, they could market as a prescription product only. And if it was a prescription product, it had to carry the label, "Caution, federal law prohibits dispensing without a prescription." And the Kefauver-Harris Amendment ramped it up again by saying that the drug had to be safe and it had to be effective. And they were also required to wait on the government or the FDA to approve the application. So that meant that there was a queue and you had to wait. It wasn't one of these where there was automatic approval. So the Food, Drug, and Cosmetic Act of 1938 established that drugs had to be generally recognized as safe. Drugs prior to that law were grandfathered in, and there was no requirements that they were required to be safe. Now in 1962, the Kefauver-Harris Amendments were passed, establishing that drugs had to be generally recognized as safe and generally recognized as effective. And that applied to drugs from 1938 on. So it's important to keep that straight and not to get that mixed up, because it'll probably be on the MPJE. So just to kind of tie it all together, the Pure Food and Drug Act of 1906 established adulteration and misbranding. These are two terms that are still used today. The Federal Food, Drug, and Cosmetic Act of 1938, because of the sulfanilamide disaster, established that drug companies had to prove that their drugs were safe. The Durham-Humphrey Amendment of 1951 created over-the-counter and RX categories. And to tie it all together, the Kefauver-Harris Amendment of 1962 required that drugs be proven safe and effective, and drug manufacturers had to wait on the United States government to approve their product via the FDA prior to marketing. All right, thank you guys for watching, and I will see you soon. So thank you guys for watching my first lecture. If you want to keep going, click on the link below. I want to thank you guys for watching. If you have any questions or anything, shoot me an email at jeffprep@jefffpharmacist.com. I want to thank you guys for watching. Thanks a lot.